morning. Thank you very much for joining us for this new series of European law interviews. This program is sponsored by the Jean Monnet Chair, which is part of the European Commission Education and Training Program. We have the great chance today to interview Professor Nicolas de Sadeleer. He is a professor in EU and environmental law at Université Saint-Louis Brussels and Université Catholique de Louvain. Good morning, Professor.
Hello.
Thank you very much for joining us. In other interviews, we discussed negative harmonization. We broadly explained this topic. There is a first possibility for negative harmonization. So if EU institutions did nothing, member states are free to carry out their own environmental policies as long as they do not hinder free movement of goods. And it's possible, if institutions have done something, to invoke grounds of justifications, as we discussed earlier, for example, Article 36 TFEU. Today we will focus much more on positive harmonization, so when there are directives and regulations. Here there are limits, substantial limits and procedural limits to the freedom of member states to carry out their own policies. Here it's very important to find the right legal basis, because we can have on the one hand a copy-paste of what is in directive and regulations, or we can have the wish to go beyond and the possibility to go beyond. So there are two possibilities. We can use either Article 114, either Article 192, and today's interview is going to focus on Article 192 and then Article 193. If you don't mind, I'm going to reread Article 193 to make sure that all people watching us remember the exact wording of this provision, okay?
Yes, please.
So this article reads: the protective measures adopted pursuant to Article 192 shall not prevent any member state from maintaining or introducing more stringent protective measures. Such measures must be compatible with the treaties. They shall be notified to the Commission. Okay, so Professor, my first question is on the importance of that provision. So basically, how important is that provision to the member state wishing to pursue a higher environmental protection?
Well, firstly, I would like to emphasize that Article 193 is related to Article 192, and 192 is the legal basis for the EU institutions to adopt a flurry of directives, regulations, decisions, some of which are placing upon product-specific requirements. So in sharp contrast to Article 114 on the functioning of the internal market, Article 192 related to Article 193 allows the member state to enact more stringent measures. Second remark is that Article 193 reflects the principle of subsidiarity. Environmental policy within the EU is impinged by such a principle. So the member states are actually better placed to carry out an environmental policy in its own right than the EU institution. Third remark is that Article 193 grants broad autonomy to the member states to go further, to enact more stringent rules than the ones laid down in EU secondary law. And of importance is to note that the member state authorities are not obliged to request an opinion or an authorization from the European Commission to enact such more protective rules. They can decide in their own rights to move on and to go much further than the procedural or the substantial obligations laid down under the directives. Practically speaking, that's of utmost importance whenever the member states want to get rid of derogations, want to introduce more stringent procedural standards, want to increase pollution or risk thresholds, or wish to extend the field of application of a specific regime.
This part of EU law is quite difficult to grasp, especially for students. So, do you mind giving an example?
Well, by way of illustration, the Birds Directive is protecting all bird species across the EU. But the Birds Directive authorizes to some extent hunting, catching of different species of birds. The 3 Belgian regions are authorized to hunt, to allow hunting of a limited number of species, but nothing prohibits, in accordance with Article 193, the Belgian regions to reduce the list of species of birds to be hunted. Accordingly, the region of Brussels has been prohibiting the hunting of mammals as well as birds for safety reasons. As one can imagine, it's a highly populated place, but they can do that in accordance with Article 193, but it will be much more difficult to act in such a way regarding chemical substances that are regulated mostly through directives and regulations adopted under Article 114.
Okay, and so if we go back to the exact wording of Article 193, this article requires a notification to the Commission. Is there a specific time limit for this notification?
Yes. Well, of importance is to note that the provision requires, as you are stressing, notification, and so that notification is not part of an authorization procedure. The European Commission is being informed of the national measures fleshing out the provisions either of the directives or the regulations or the decision, and accordingly there is no time limit. However, in accordance with the principle of good faith and the principle of loyal cooperation, the member state should convey the information as quickly as possible. But Article 193 does not lay down any specific timetable, unlike the notification directives 98/43. So the approach is completely different.
Okay, thank you very much. We'll now move to a much more difficult and broad question. So, are member states allowed to invoke Article 193 in order to depart from an act adopted on the basis of Article 114 that seeks maximum harmonization?
No, that's frankly speaking, that's impossible.
Okay.
In case a member state is wishing to enact more stringent procedural or substantial standards than the one laid down in a regulation adopted on the basis of Article 114, that member state must follow the procedure in accordance with paragraph 4, 5, 6 of Article 114. So Article 193 cannot empower the member state to circumvent the derogation procedure provided for under Article 114.
Okay, and so if I understand you well, the definition of the extent of the protection to be achieved is defined by member states, so they have a quite significant discretion in carrying their own environmental policies.
Yeah, rightly so. In Brussels region, one cannot hunt birds anymore, whereas the directive allows the Belgian region to hunt different species of ducks and geese.
Okay,
but that was a decision made by the region to ban hunting, among other animals, of birds.
You just said that member states are allowed to adopt more stringent measures on the basis of Article 193. Is it possible to do the contrary, so to use this article, so Article 193, to adopt less protective measures?
No, that would be definitely in breach of Article 193. the idea is to increase the level of protection. Of importance is to know that different provisions of the Treaty on the European Union and Treaty on the Functioning of that Union emphasize the need to achieve a high level of protection. So the approach is dynamic. Member states could perhaps depart from a very high level of protective standards in as much as they are expressly authorized by the EU institutions. But they cannot do it on the basis of Article 193.
Okay, thank you very much. And if we go back once again to the wording, the exact wording of Article 193, there is a requirement for the more stringent measure to be compatible with treaty law. How should we interpret this requirement?
This is really an awkward question. I imagine that one must draw a dividing line between more protective national provisions that do not impinge upon economic rights enshrined in treaty law. And on the other side of the dividing line, one is facing a situation in which the national measures do impinge upon free movement of goods or free provisions of services.
Okay.
So firstly, I shall address the first situation. Whenever the national measures does not impinge upon a free movement of goods, for instance, well, the Court of Justice cannot review the proportionality of the measure. So the proportionality principle that's embedded in the review of Article 34 is of no application in such a situation. So the Court of Justice has been very clear on that point in a German case related to higher standards applied to landfilling household waste. On the contrary, in situation in which the waste management more protective measures is likely to hinder directly or indirectly, potentially or actually free movement in waste, then the national authorities should take into consideration that impact and perhaps reduce accordingly its level of protection with the aim of not infringing this economic right. So Article 34 precludes higher standards that are likely to jeopardize free movement of goods.
Okay.
You know?
So if I understand you well, if there is no breach of treaty law, so if the national measures do not infringe free movement of goods, etc., member states might adopt more stringent measures, and those measures will not be subjected to the proportionality principle.
Yes,
Okay.
indeed.
Let's move to...
But it will be the opposite regarding
of course.
measures regulating waste and accordingly impacting upon export or import of waste.
Of course, of course. Do you have an example of a more stringent measure that is likely to be subjected to the proportionality principle?
There was an interesting judgment handed down by the Court of Justice in the case Azienda Zootecnica Francini. The Italian authorities have been designating a number of mountains, lakes, meadows as Natura 2000 sites. Some Italian regulations prohibit the operation of wind turbines in these areas on the account that they can be a threat to eagles or storks or flamingos, for instance. Some developers wishing to build wind turbines within a Natura 2000 site contended with the proportionality of the Italian approach to the Natura 2000 sites. In their views, the Italian legislation went too far in prohibiting the operation of wind turbines. So the Court of Justice was asked to rule on the matter of proportionality. Given that the prohibition of operating wind turbine within the Natura 2000 site did not impinge upon other treaty provisions, such as the one laid down under Article 194 that's promoting renewable energy within the EU, well, the Court of Justice took the view that the principle of proportionality was of no application in that case.
Okay, thank you very much. Then the last question, is it possible to invoke Article 193 in order to circumvent the duty of loyal cooperation enshrined in Article 4.3 TEU?
It's a very interesting question. The Swedish authorities have been invoking Article 193 to justify the proposal to list under the Stockholm Convention on Persistent Organic Pollutant specific chemicals, in spite of the opposition of the European Commission. The Commission has been challenging before the Court of Justice the willingness of the Swedish authorities to propose to list that substance on the ground that it was in breach of this principle of loyal cooperation. And the Court of Justice ruled on the case in deciding that Article 193 could not justify such a breach of that principle.
Okay, so thank you very much for all those precious and very fruitful information. This is the end of our interview on Article 193 TFEU. So we saw that it is possible for member states to adopt more stringent environmental measures, but there are limits. For example, it is important to notify to the Commission, and there is of course a time limit to do so. Then it's impossible to adopt less stringent measures, it's only for more stringent measures. We saw that it's important to make sure that we understand the importance of all requirements in Article 193. And finally, we saw that it is impossible to use Article 193 to circumvent the principle and the duty of loyal cooperation. Thank you very much, and see you next week.